Hello students, welcome to EPG Pathshala. I am Prakash Sharma from Faculty of Law, Delhi University. Today we are going to discuss about module Women and Labour Laws 2 under paper Women and Law, subject Women Studies. The objective of this present module is that ensure better understanding of prevailing rights of women workers under vital legislations that address women workers' concerns and highlights a need for adequately resolving them. The scheme of presentation is we will discuss certain introduction. Thereupon, we will be discussing about Right to Equal Remuneration Act, right to maternity leave, right to maternity leave for government servants, and thereupon, finally, we will have conclusions. Economic dependence of women is what gives rise to their subordination in society today. Hence, to remove such subordination and to lay foundation of equality, women must be made economically independent and play an active role in all sectors of business today. Problems faced by women in economic sphere of life are mostly related to unequal wages and discrimination resulting from their biological role in nature of childbearing. To curb such problems and protect the economic rights of women, the legislature introduced the Equal Remuneration Act of 1976 and Maternity Benefit Act of 1961. Now, right to equal remuneration. Parity in wages is one of the major components of service laws jurisprudence, which has evolved over the years. If two workers are doing the same work, they should be paid equal wages. Article 39 of Indian Constitution envisages that state shall direct its policy, among other things, towards securing that there is equal pay for equal work for both men and women. To give effect to this constitutional provision, the Equal Remuneration Act of 1976 was passed to provide for payment of equal remuneration to men and women workers and for prevention of discrimination on the ground of gender against women in the matters of employment and for matters connected therewith or incidental thereto. Now, two of the essential provisions that we are discussing in this particular module, we will be discussing about right to equal remuneration. Parity in wages is one of the major component of service law jurisprudence, which has evolved over the years. If two workers are doing the same kind of work, they should be paid equal wages, is what this particular service law jurisprudence discusses about. Now, we are going to discuss about certain constitutional provisions. Article 39 of the Indian Constitution envisages that the state shall direct its policy, among other things, towards securing that there is equal pay for equal work for both men and women. To give effect to this constitutional provision, the Equal Remuneration Act of 1976 was passed to provide for the payment of equal remuneration to men and women workers and for the prevention of discrimination on the ground of gender against women in the matter of employment and for the matters connected therewith or incidental thereto. Equal pay for equal work for women and men is a vital subject of greater concern, both for the society in general and for the employees in particular. There was a common belief that women are physically weak and should be paid less than their male counterparts for the same kind of work that they have been working upon. Women all over the world had been very much inarticulate and were prepared to accept lower wages. However, they have been employed in the same job as that has been done by the men. Even in the economically and socially advanced countries where remarkable progress has been made, discrimination still exists. Recently, in various newspaper articles, we have come across this particular aspect. In India, in the initial stages, when legislation for protection of workers was hardly thought of, factory owners taking advantage of the backwardness and property and poverty recruited women on large scale at lower wages and made them work under inhuman conditions. International Labour Organization has evolved several conventions to provide protection to employed women. A number of ILO conventions have been ratified by India, and some of these, though not ratified, have been accepted in principle. The Equal Remuneration Convention of ILO was ratified by India in 1958. The Equal Remuneration Act 1976 prohibits discrimination on the basis of gender at the time of recruitment of any condition in service subsequent to recruitment, such promotions, training, or transfer. This prohibition is similar to the one contained in Article 16, Clause 1 of the Constitution of India. The Act, however, does not apply to unorganized sector, where most women do work. Unorganized sector is that where there is no formal or informal structure, which gives laborers an identity for the purpose of bargaining or decision making against the employer, like construction workers, domestic workers, etc. Section 2G of the Act defines remuneration as the basic wage or salary and any additional emolument, either in cash or in kind, payable to a person in respect of employment or work done in such employment. Section 4 of the Act imposes an obligation on the employer to pay equal remuneration to men and women for the same work or work of a similar nature. Same work or work of a similar nature means work in respect of which the skill, effort, and responsibility required are the same. When performed under similar working conditions by a man or a woman, and the differences, if any, between the skill, effort, and responsibility required of a man and those required of a woman are not of a practical importance in relation to the terms and condition of employment, then those are also covered within the definition of same work or work of a similar nature as defined under section 2H of the Act. Some other important provisions of the Act are: there is the employer is duty bound to pay equal remuneration to men and women workers for the same work or work of a similar nature as been covered under section 4 of the Act. Section 5 says discrimination must not be made while recruiting men and women. Further, section 7 says authorities for hearing and deciding claim and complaints must be defined. Section 8 deals with maintenance of registers. Also under the Act 1976, no discrimination is permissible in recruitment and service conditions, except where employment of a woman is prohibited or restricted by the law. The Central Ministry of Labour and Central Advisory Committee regularly monitors the situation regarding enforcement of provisions of this law. In Jitendra Prasad Singh versus Telco 1999 case, court opined that principles of equality are virtually in the nature of natural law, and denial of equality would be against the very constitutional provision of Article 14 of our Constitution. Also in Dharwad District PWD Literate Daily Wage Employees Association versus State of Karnataka 1990 case, court held that Equal Remuneration Act of 1976 provides for payment of equal remuneration to men and women workers for the same work or work of a similar nature and for the prevention of discrimination on the ground of gender. The deciding factor in cases of equal wages is same or similar work principle. However, this principle leads to adoption of indirect means of fixing lower wages for women, like dividing the jobs into grade 1 and grade 2 and then employing women in the lesser grade, thus overriding the equal remuneration provision. In Air India versus Narges Mishra, the air hostess of Air India brought a case against their employers, contending that they were being discriminated against assistant flight pursers who did more or less the same kind of work on flights but had better service conditions and other facilities. The Supreme Court struck down the provisions of rules which stipulated termination of service of an air hostess on her first pregnancy, and it was held arbitrary and abhorrent to the notions of civilized society. Further, Supreme Court granted some influential concession to the petitioners like raising of retirement age and declaring the provisions requiring termination of services of air hostesses on pregnancy as unconstitutional. However, it have upheld the discriminatory conditions of service. At the same time, the court conceded that functions of two, though obviously different, overlap on some points, but the difference, if any, is one of the degree rather than of kind. Thus, although the air hostesses and assistant flight pursuers do almost the same work, the conditions of service of the two cadres are different, because of which sex discrimination could not be established. This highlighted the weaknesses of test of equal pay for same or similar work in the Act. Further, in McKinsey and Company Limited versus Audrey de Costa, 1987, the court held that in deciding whether the work is of same or similar nature and in ascertaining whether the differences are of any practical importance, the authority should take a broad view of the matter. This is because the very concept of similar work implies differences in detail. These differences should not defeat the claims of equality on tribal grounds, but look at the duties actually performed and not those theoretically possible. The court further gave its verdict that there should be proper job evaluations whenever sex discrimination is alleged. The court directed that this should be done on the basis of non discriminatory criteria, which looks directly to the nature and extent of the demands made by job and does not apply different values for men and women on the same job. It is found that men and women employed on those jobs are paid differently. Then the gender discrimination clearly arises. It was further held that the question of equal work depends on various factors like responsibility, skill, effort, and condition of work. If a lady stenographer was doing work of the same kind as a male stenographer, then irrespective of the place where they were working, the employer was advised to pay equal remuneration. The court pointed out that if women were at a particular job, it was only because the management wanted them there and not because they could not do the work assigned to male stenographers. Therefore, equal wages could not be denied to a woman employees. In People's Union for Democratic Rights versus Union of India, 1982, it was alleged before the court that the workers engaged in construction work were being discriminated in matters of payment of wages on the basis of gender, which is violative of the provisions of Equal Remuneration Act of 1976. It was contended in the writ petition that women workers were getting paid only rupees 7 per day, whereas the fixed fee for men was rupees 9.25, and that the balance amount was being appropriated by the contractors. In this case, the court held that non-payment of equal wages was a violation of right to equality under Article 14 of the Constitution and directed government and Delhi administration to ensure that the provisions of Equal Remuneration Act of 1976 were not violated. For the purpose of effective implementation of Act, the appropriate government is required to constitute one or more advisory committees and appoint inspectors. The employers are under an obligation to maintain registers and other documents in relation to the workers employed by them. Failure to maintain such registers or documents or to produce any register, muster roll or other document is an offence covered under section 10 of the Act. Further, while the Act provides for advisory committees, inspectors and registers which have to be maintained by the employers, and even penalties for employers grace from their duties. Implementation of Act has not been successful, largely due to lack of monitoring at the level of the factories and the respective establishments. Amongst unorganized sector workers, women are paid less than men in almost all forms of employment. Employers divide the kind of work done between men and women and technically evade the provisions of Equal Remuneration Act of 1976. The recommendations of ILO that equal remuneration must be based on work of equal value must be incorporated into national laws. It is recommended that the Equal Remuneration Act of 1976, particularly Section 2, Clause H, and Section 4 and Section 5, are to be amended to include work of equal value in addition to work of similar nature. Coming to another important legislation, the Maternity Benefit Act of 1961 regulates the employment of women in factories, mines, the circus industry, plantation, and shops or establishment employing more than 10 or equal to 10, except the employees who are covered under the employee state insurance for certain periods before and after childbirth, and provides for maternity and other benefits. Some of the essential provisions for the Act of 1961 are: it defines child, which says it includes stillborn child. It defines maternity benefit and means that the payment referred to it in subclause 1 of section 5. Establishment is also been defined, and it means factory, a mine, a plantation, an establishment wherein persons are employed for the exhibition of equestrian acrobatic and other performance. A shop or establishment or an establishment to which the provisions of this Maternity Benefit Act of 1961 have been declared under Section 1, subsection 1 of Section 2 to be applicable. Employment of or work by a woman is prohibited during certain periods as covered under Section 4 of the Act. Notice of claim for maternity benefit is also been defined and covered under Section 6 of the Act. Every employer shall prepare and maintain such registers, records, and muster rolls in the prescribed manner as has been defined under Section 20 of the Act. Right to maternity leave. Motherhood is one of the most important jobs. Children should be well cared for and groomed into responsible citizens of the world. Maternity leaves aims to help women to return to the workplace and to take care of their newborn babies at their most vulnerable age. Paid maternity leave policies have a significant impact on infant and maternal health. Women who have sufficient paid maternity leave are much more likely to breastfeed, and breastfeeding lowers the risk of all sort of infectious disease in the infant. Article 25 Clause 2 of Universal Declaration of Human Rights 1948 acknowledges that fact that motherhood requires special care and attention. International attention of maternity protection of world community was attracted when ILO convened the first maternity protection conference in 1919. In this, the matter related to maternity leave, economic benefits during absence of from work, leave from bringing of children, and non-termination of service during pregnancy and immediately after delivery were deliberated upon, and a resolution was passed. The resolution of this convention was amended in 1952, which increased maternity leave, economic benefits, and added some more benefits to the mothers of newborn children. Keeping the view of ILO convention and the fact that there was a need for providing maternity benefits, Article 42 of Indian Constitution directs the state to make provisions for maternity relief. A maternity benefit is one that every woman shall be entitled to, and her employer shall be liable for the payment of maternity benefit, which is the amount payable to her at the rate of average daily wages for the period of her actual absence. The Maternity Benefit Act aims to regulate employment of women in certain establishments for certain periods before and after childbirth and provides for maternity and certain other benefits. This is a piece of labor legislation exclusively devoted to working women in factories, mines, plantations, and establishments wherein persons are employed for the exhibition of equestrian, acrobatic, and other performances. It applies to every establishment belonging to the government except those factories or establishment to which provisions of Employee State Insurance Act of 1948 are applicable. Under the provisions of this act, a pregnant woman has been given protection in order to protect her health as well as to avoid any interference which may be detrimental to the sound development of the unborn child. Women can claim benefits under the act everywhere except in factories and the other establishment where the Employee State Insurance Act is applicable. Women who are employed either directly or through a contractor and have actually worked in establishment for a period of at least 80 days during the 12 months are eligible to claim the benefits under this act. Section 4 of the act gave a pregnant woman protection of her health and to avoid any interference which may be detriment to the sound development of an unborn child. During the pregnancy, she shall not be given any work of the nature which is unlikely to cause interference with her pregnancy or the natural development of the fetus, or likely to cause her miscarriage or otherwise be adversarial to her health. Thus, effective safeguards have been provided for sound development of child and the maintenance of health of the mother. The maternity benefit is a payment to a woman worker at the rate of average daily wage for the period of her actual absence immediately preceding and immediately following the day of her delivery. Wages for the purpose of this act mean all remuneration payable in cash to a woman and includes such cash allowance as a woman is for the time being entitled to, like dearance allowance and house rent allowance, etc. For the purpose of maternity benefit, the average daily wage means the average of women's wages payable to her on the days on which she has worked during the period of 3 calendar months immediately preceding the date from which she absents herself on account of maternity. Any woman who is entitled to maternity benefit has to give notice in order to receive the benefits. If she fails to do so, she has to make an application with the inspector for the purpose. Appeal against the of the inspector lies to the appellate authority, which must be made within 30 days from the date of a decision of inspector and that has to be communicated to her. The decision of the appellate authority is always final. However, if she is dissatisfied with the order of the inspector or the appellate authority, she may approach the courts of competent jurisdiction. Discharge or dismissal during maternity leave is considered to be void. When pregnant woman absents herself from work in accordance with provisions of this act, it shall be unlawful for her employer to discharge or dismiss her during or on account of such absence or give notice of discharge or dismissal in such a day that notice will expire during such absence or vary to her disadvantage any of the condition of her services. Dismissal or discharge of a pregnant woman shall not disentitle her to the maternity benefit or medical bonus allowable under the Act except if it was on some other grounds. Failure to pay maternity benefits or discharge or unemployment of women due to maternity will result in imprisonment of employer for not less than 3 months, which may extend to 1 year, and a fine of rupees 200, which may extend to 5,000. As per Section 9 of the Act, in case of miscarriage or medical termination of pregnancy, the woman is entitled to leave with wages at the rate of maternity benefit for a period of 2 weeks immediately following the date of her miscarriage or medical termination of pregnancy, as the case may be. Section 9A of the Act provides in case of a tuberculosis operation, a woman is entitled to leave with wages for a period of 2 weeks immediately following the day of her operation. In case of any illness arising out of pregnancy, the permitted leave may extend to maximum period of 1 month. Under Section 11 of the Act, every woman who delivers a child and returns to duty after such delivery is entitled to usual break for nursing the child until the child attains the age of 15 months. Violation of provisions of the Act will result in penal consequences. The object of an act is to remove any discrimination faced by women because of the biological role she is required to play. The good intentions of the legislatures seem to have backfired since employers refuse to employ married women in order to avoid paying maternity benefits. In some cases, marriage itself is a disqualification, while in others, pregnancy acts as a bar to employment. The Supreme Court, in number of cases, has held that such practices are unconstitutional. In Air India versus Nargesh Mirza, 1981 case, the Supreme Court struck down the provisions of rule which stipulated termination of service uh, on the basis of pregnancy and held those provisions, rules arbitrary and abhorrent to the notion of a civilized society. In the case of B. Shah versus Presiding Officer, Labour Court, 1978, wherein the petitioner claimed that she was paid her maternity benefit wages by deducing the wage due to her on Sundays, the Supreme Court defined the term week to include wages for 7 days, including Sundays and not just 6 days. The court, while applying the principle of Article 4 of ILO's Maternity Protection Convention number 103, 1952, held that the act is a beneficial social legislation and thus will fall under the purview of Article 42 of the Indian Constitution. In order to provide more benefits to a pregnant employee, the Maternity Benefits Amendment Act 2017 was passed by Parliament. The salient features of the amending act are: maternity leave available to a working woman has increased from 12 weeks to 26 weeks for the first two children. The maternity leave for the children beyond first two will continue to be 12 weeks. The maternity leave for 12 weeks to be available to mothers adopting a child below the age of 3 months, as well as the commissioning mothers from the date of child is handed over to them. The commissioning mother has been defined as a biological mother who uses her egg to create an embryo planted in any other woman. In other words, even the surrogate mother is entitled to maternity benefits. Every establishment with more than 50 employees is required to provide for crèche facilities for working women, and other women will be permitted to make 4 visits during working hours to look after and feed the child in the crèche. The employer may permit a woman to work from home if it is possible to do so. This has come into an effect from July 1st of 2017. Every establishment will be required to make these benefits available to a woman from time of her employment, and they are required to intimate them about these benefits in writing form. The National Maternity Benefit Scheme launched by the government was modified and new schemes called Janani Suraksha Yojana was introduced. Right to maternity leave for government servants. The Central Civil Services Leave Rules 1972 provide maternity leave, paternity leave, leave for adoption, and childcare leave for all central government employees. A female government servant with less than 2 surviving children may be granted maternity leave by the competent authority for a period of 180 days from the date of its commencement. During this period, she is entitled to be paid leave salary equal to the pay drawn immediately before proceeding on leave. For miscarriage, including abortion, maternity leave for a period of 45 days may be granted. Women employees having minor children may be granted childcare leave by an authority competent to grant leave for a maximum period of 2 years during her entire services for taking care of up to 2 children, whether for rearing or to look after any of their needs like examination, sickness, etc. Child care leave is not admissible if the child is 18 years of age or older. It may be availed of in more than one spell. Rule 43 Clause A provides that Male government servant with less than two surviving children may be granted paternity leave for a period of 15 days during the confinement of his wife or childbirth, that is up to 15 days before or up to 6 months from the date of delivery of the child. During this leave period, he shall be paid leave salary equal to pay drawn immediately before proceeding on leave. In 2009, paternity leave was extended to fathers with less than two surviving children on adoption of child or less than 1 year of age to be taken within 6 months of valid adoption. Adoption leaves are available to female government servants. Child adoption leave available to female government servants extend to 180 days as discussed earlier. However, no maternity leave is available to a surrogate or a commissioning mothers. We shall be discussing about two government policies has been adopted by the respective states. Tamil Nadu government policy on maternity leave provides 9 months of maternity leave. The leave can spread from pre-delivery rest period to post-delivery recuperation period at the option of the employee. Maternity leave was first extended to 90 days in 1980 and was doubled to 180 days in 2011. This was further increased to the present 9 months in 2016. Another government, West Bengal government on maternity leave provides for 180 days of leave similar to that of central government employees, whereas the paternity for the fathers in West Bengal is for 30 days, which is more than the available to the fathers in central government. Conclusion: the right to equal treatment with respect to employment protects persons in all aspects of employment, including applying for a job, recruitment, training, transfers, promotions, terms of apprentice, dismissals, layoffs, and terminations. This also covers rate of pay, code of conduct, overtime, hours of work, holidays, benefits, shift work, performance evaluation, and discipline. However, even with the presence of sufficient provisions for protection of rights of women in employment by statutes discussed above, these seems to be need to give the child care leave in private sector at par with the of government employees. It is therefore suggested that fundamental starting point for complying with the legislative intent, especially in relation to all of the above mentioned requisite, is to have a workplace setting where human rights are respected and applied. Thank you.